Hello, welcome back to our update for Module 5, Chapter 5. This is the next step along the way, the non-statutory labor exemption that we looked at in Chapter 4. We're focusing on age eligibility rules and professional drafts across the three major leagues. We did skip over the NBA challenges to player challenges to NBA practices, the Wood, Williams, and Caldwell basketball trilogy. We'll come back to those. That's at page 145. But we're forging ahead with help from Erin, who's going to help take us through this most recent age eligibility case, Claret having been the most important one up till now. This one is really an important case for us to understand, Erin. And thanks for taking us through it. And we'll have Mike McCann here to talk to us about it. And of course, he was one of the lawyers on the Claret case itself. So please, the floor is yours, Erin.
Great. Yes, thank you, Professor. So this year we had, like you said, one of the biggest age eligibility cases of recent history. It was Olivia Moultrie, who at the age of just 14 or 13 years old, she signed a 9-year endorsement deal with Nike. So this is a person who is well beyond the skill level of a general 13-year-old. And by this year, she was 15. She filed suit against the National Women's Soccer League. Olivia Moultrie is a soccer player. And she filed suit because the league had a unilaterally imposed age restriction that nobody in the league could play until they were 18 years old. That clearly affects Moultrie, as she has many years to go until she will be 18. So she filed suit. She had already been practicing and scrimmaging with the Portland Thorns. She wanted an opportunity to be able to play in the league. And members of the Portland Thorns team had said that not allowing her the chance to play would impede her career. She's really playing at her peak right now. So the crux of her suit against the NWSL depended on whether or not the league's rule was going to be exempt from antitrust scrutiny, which could have been achieved one of two different ways. First, if the rule had been collectively bargained for between the NWSL and the NWSLPA, if it had, it would qualify under the non-statutory labor exemption. However, Moultrie's attorneys maintained that as the league was newly formed and did not currently have a collectively bargained agreement, that this was not a negotiated rule, and that instead it was NWSL's rule. Many were quick to point out that this was going to interact with Claret, which was a case where the NFL's age eligibility rule was sustained, though not actually in the text of the CBA. And that's available in the textbook, pages 156 to 159. So that was one way that we might have, that the league might have gotten the rule around antitrust scrutiny. The other, which I think Ellie spoke to in Chapter 4, was the single entity sports league defense. So if the league owned all of the teams and paid all of the personnel, then it would be a single entity, and it would not have to be required to comply with Section 1 of the Sherman Act. Other leagues like the NFL, NBA, and MLB are all independently owned, so those teams are competing businesses and required to comply with Section 1 of the Sherman Act, which means that they can't conspire to harm competition. So if the NWSL were a single entity, then it could unilaterally impose rules like this. But a federal judge in Oregon, Judge Immergut, found that neither of those rules should apply and granted a temporary restraining order blocking the age restriction. Specifically, she found that the age rule was not bargained for, as they were currently in negotiations, and that the NWSL was not a single entity. So Moultrie's framing of the issue really won out in the judge's opinion. Judge Immergut said, as of the date plaintiff's complaint was filed, more than half of the MLS teams allegedly had one or more players on their roster under the age of 18. In other words, the only thing currently standing between plaintiff and her aspiration to be a professional soccer player in this country is her gender. Promoting gender equity in athletics is clearly in the public interest. So Moultrie's team had both argued against the antitrust or the league's defenses on antitrust scrutiny, but it also really framed the issue as one of gender equity, because Major League Soccer at this point does not have a similar age restriction. So the attorneys wisely, it seemed, made this one of an argument about gender equity, and the judge was persuaded. So the temporary restraining order that Judge Immergut granted just allowed a 2-week window blocking the rule. And during that 2-week window, Moultrie did sign with the Portland Thorns, like I said, who she had already been practicing and scrimmaging with. And then later this summer, the league and Moultrie reached a settlement, and the league dropped their appeal to the Ninth Circuit of Judge Immergut's decision. And the league has agreed that Moultrie can play unless and until a collectively bargained rule states otherwise. So at this point, we're waiting to see whether or not the league and the Players Association come to a collectively bargained agreement with an age restriction or not. But for now, Moultrie is playing in the league and seems to be doing well.
Awesome. Thanks so much, Erin. And let me just add that you did mention MLB, and of course we know about the antitrust exemption, but reading backwards to Silverman, we know that once the Players Association and the owners of Major League Baseball are at the negotiating table, they must abide by the same labor laws as the other two leagues. So that exemption, Silverman is so instructive there. I keep coming back to it. And the study guide at 114 and following in chapter 3, reading back and reading forward to talk about the carve-outs from the MLB antitrust exemption. But once they're at the table, they're just treated like every other league too, which Silverman brings to the fore. And the only thing I would add is, we forgot to mention, but this whole non-statutory labor exemption, which comes out of the Labor Management Relations Act, Section 301, really comes out of the 3 cases cited at 130. And these are, as Jeff Pash again said, is it Jewel T, Pennington, Connell Construction, page 130. These are hard, very difficult, very tricky, major, unions engaging in 3 Supreme Court case determinations that ultimately said that Labor Management Relations Act will govern in this area, and that's really another important point to keep making throughout both chapters 4 and 5, and it'll really come to a head in chapter 6 when we look at drug and injury related issues, because section 301 of the LMRA at page 194 will certainly tell us that any grievance, star caps being one of the very few exceptions, it just snuck outside of LMRA, but otherwise final binding arbitration that's been agreed to by a union and management, the ownership council, are going to stay in final binding arbitration. It's almost impossible to get out and file an antitrust or even an injury grievance sort of a case. So that's a long addition to a wonderful summary of the Moultrie case. So thank you very much, Erin. Terrific. Okay, NFTs, Mike McCann has written about this. He's going to be joining us week 5. So we thought we'd just take a quick look at it and go ahead. I think, Ellie, you volunteered in the classic case of volunteering, meaning I asked you to take us through this real quickly. So non-fungible tokens, blockchain, technology, tracing NFTs back to its original owners. This will also tie into Dolores DeBell a little bit when she visits us for module 7 and IP and licensing issues. But how does this tie into who owns what revenue streams?
Yeah, look, there's a lot going on here. And I think this is the classic case of you get technology develops and then the law ham-handedly attempts to catch up in the ensuing years. So the non-fungible token is a way to have a file housed in a particular location wherein you can see every transaction that has occurred to that file. And most importantly, you can trace it back to its original owner. This has revolutionized, if you take the optimistic view, or has had a flash in the pan if you take the pessimistic view, but at least has had a major impact in the year of 2020 and to an extent 2021 on art, on music, and as we see in sports now, in the distribution of highlight clips. So various leagues attempted to get somewhat involved with this. The NFL wasn't super interested. Major League Baseball was interested to a degree, and the NBA jumped in with both feet. The NBA created this program called Top Shot. And the easiest way that I could analogize this to something that I think a lay sports fan, who's not too technically savvy would understand, is this is sort of like trading cards, right? So like when you buy a pack of trading cards, you might ask, well, why does it matter if I have the first edition of something? Is the same reason you might ask a trading card collector, why does it matter if you have a printing plate card or a 1 out of 1 gold plated card or something along those lines from Topps or Upper Deck or Fleer or the like? Top Shot kind of gave this to the market. People got very interested in it. And then, a lot of money changed hands, and folks both in the government, in plaintiff side law firms, Mike McCann himself wrote an article about this, started to then ask the questions of, well, hold on a second here. What about fraud? What about the liquidity of the money that you're putting into here? And if we could scroll down to the next page, perhaps the most interesting aspect of it, if you're just, sort of a regulatory geek, is whether these are regulable under the Securities and Exchange Act, by the SEC. So that's the generic legal framework. Is you have this cool new technology. Sports leagues got interested in it, particularly, the super tech forward NBA, of course, takes the leading role. And people start asking questions about it. That's normal. I think we generally understand that. What's now going to be the bigger question, I think, is, you got pretty crazy numbers, as a general matter, into the billions of dollars for the NFT market writ large. And now what you have is, at least for today and at least for tomorrow, I can't speak to 5 years from now, but at least for right now, a pretty unique source of revenue that is going to be lining the league's coffers for at least a little bit of time. Whenever you have new revenue, particularly that's based on stuff related to the players and the Top Shot, the files that they sell on the blockchain are highlights of, everything from a LeBron James dunk, Steph Curry 3-pointer, etc. And they're selling that. The players are going to want their cut. And so, in the absence of language in a collective bargaining agreement that speaks specifically to NFTs, both sides are going to make their arguments. The NBA might say, well, this is part of XYZ revenue, that we've already talked about. And the players will say, well, no, it's not, or we want to negotiate it. And so, do you get an antitrust suit out of that? Probably not under the governing precedents. But this goes back to, I think, a few cases that we're familiar with of defining the scope of what the business of a given sport is, and what antitrust protections extend to that, because this, I don't think, is what we would typically understand as a classic topic of collective bargaining: wages, hours, and working conditions.
Ellie, that's a perfect preview of Dolores DeBellis visiting us for intellectual property rights as they relate to the 3 major leagues. And she'll get to that. The NBA's publicity rights are mentioned at page 216, and it really does go back to chapter 2. So this is all in one piece, where the publicity rights are collectively bargained up to a point, but we're at the edge of that point. And then the question, as you say, is going to be, as these revenues develop, how are they going to be collectively bargained, because they're generated, yes, by that which perhaps the league archivally owns, but without the player attribute, there's no product. So we'll watch that space. Again, reading back to chapter 2 in the Uniform Player Contract, we talk about what the player gives up in terms of publicity rights, and reading all the way into chapter 7, where we look at Paxson and Valentine and some of the challenges that tried to restrain the trade of certain of the players back in the day.
And to add one more,
sure, of course,
one more update here. I just actually saw this come through a couple hours ago. The NFL, the NFLPA, and Dapper Labs, who is associated with the NBA Top Shot, are going to it says, likely announce this week a partnership between them three to create essentially NBA Top Shot for the NFL. So again, one of the biggest league in the country is going to be getting into this, and I guess biggest league in the world as well. So again, you'll see this continue to grow, and thanks, Ellie, Professor Carfagna, and Erin, for a lot of the legal insight on where we're going to go moving forward.
Interesting that they're involving the NFLPA too. That would seem to head off a potential dispute.
Watch this space. That's why we call it, of course, the legal evolution, right? America's three major leagues. More to follow when we see Mike McCann, week 5. Erin, I'm calling the other Erin, Professor Caputo, for the day. So Erin Savoie, thank you so much for guiding us through age eligibility. And we'll close out this chapter 5 update.